Okay, well, let's get started. Good afternoon and happy Constitution Day. I'm Anthony Johnstone. I get to teach constitutional law here at the Blewett School of Law. So Senator Byrd proposed in 2004, and Congress enacted a rider in the Consolidated Appropriations Act of 2005, a rider to Section 106 of Title 36, which is, I believe, patriotic observances. And this rider, which is actually kind of hard to find, each educational institution that receives federal funds for a fiscal year shall hold an educational program on the United States Constitution on September 17th of each year for the students served by the educational institution. Now, one of the ways we observe Constitution Day is by asking whether Constitution Day itself is constitutional. And I know that the two L's have just had the general welfare power, the spending power, and we've been brushing up on South Dakota versus Dole and this fascinating health care cases, this question of coercion and a gun to the head of the state. So I was kind of wondering, well, is Constitution Day constitutional? I won't call on anyone. You did a great job with it on Monday. But, well, general welfare, clearly related to the general welfare. It's the Constitution, after all. It's related to a federal interest. I'm not sure that it's an unambiguous expression of congressional intent to condition spending on the university. We rely a lot on federal spending, and this is just kind of tucked away there in the United States Code. So it may not be an unambiguous condition. And then is there an independent bar? Is it kind of coercive? Is it a First Amendment violation that we have to talk about the Constitution every September 17th? Well, we'll leave these questions for later. I know the two L's are taking notes. In Montana, we don't need a federal mandate to celebrate the Constitution today, and we are happy to hold this event. I want to first thank the Provost's office and Claudine and Cellier and Zoe Phelan for helping out, for their support and organization of this. I want to thank my history colleague, Mike Mayer, for his leadership in developing the Constitution Day tradition here at the University of Montana. Thank our dean, Paul Kurgis, who can't be here today, for his support, and the indomitable team of Becky Garner, Carla Caballero-Jackson, Kathy Reeves, and Jerry Fox for all their assistance in getting us set up today. I'd also like to thank the American Constitution Society and their wonderful student leaders for holding a great coffee with Professor Tushnet this morning. And I'd like to thank all of you from the School of Law, and especially those of you who are joining us from across campus, maybe your first time in the School of Law, for joining us today. Now it's my pleasure to introduce our speaker. Professor Mark Tushnet is the William Nelson Cromwell Professor of Law at Harvard, where he teaches constitutional law and related courses. He's teaching First Amendment this semester. He graduated from Harvard University and Yale Law School, after which he served as a law clerk for the Honorable Justice Thurgood Marshall on the U.S. Supreme Court. Most scholars could make a career from any one of Professor Tushnet's many professional pursuits. He emerged as an early leader of the critical legal studies movement and has maintained a consistent critique from a progressive perspective of liberal judicial enforcement of constitutional rights by the judiciary. He is also an accomplished legal historian whose work includes the prestigious Oliver Wendell Holmes devised history of the U.S. Supreme Court, established by Congress with the money, a little estate planning for the students, with some of the money left over from Justice Holmes' estate. He covers the Chief Justiceship of Charles Evan Hughes, which you might recall from con law is the really exciting part during the 30s, where there may or may not have been a constitutional revolution. That book is shaping up to look like one of the major histories of American administrative law as well. And then among his prodigious and impactful scholarly output, he has published several leading case books on the First Amendment, constitutional law, and comparative constitutional law, including, I still have it, the book I studied from in con law. You guys glad we use a paperback? He is finally a wonderfully generous colleague, justly famous for his many informal scholarly workshops for junior scholars, including this junior scholar, which he affectionately calls schmoozes. The title of Professor Tushnet's lecture is Varieties of Constitutionalism, the U.S. version. If we have time afterwards, he's happy to answer questions. Please join me in welcoming Mark Tushnet.
Thank you, Professor Johnson, and I want to thank the University of Montana for sponsoring me today. I'm particularly happy to do this because last year we weren't able to organize the event for Constitution Day. Professor Johnson asked me, but I was teaching on September 17th, so I couldn't come out. But fortunately, I was able to do it this time. I should begin by saying that this is not quite, my talk is not quite a celebration of the U.S. Constitution. It's not quite a critique of it either, but I noted that the statute that Senator Byrd proposed actually doesn't say that we have to celebrate the Constitution on Constitution Day. We just have to talk about it in an educational way, and I hope that's what I'll be doing. I'm also not going to be talking exclusively about the U.S. Constitution. About 20 years ago, I started to supplement my thinking about the U.S. Constitution by looking around the world to see what constitutionalism was in other nations, and I'm going to draw on that in what I have to say. The general topic of varieties of constitutionalism is part of what I think of as a more or less long-term project, parts of which I have fiddled with and started to work on, but which, and this may turn out to be yet another part of it, but it's a long-term project and I'm not entirely sure where it's going to go, but I appreciate the opportunity to at least try out some of the ideas. Usually when we talk about constitutionalism as a distinct object of study, we need to know what it is contrasted to something else. And the usual contrast is with something like authoritarianism. And we do have a decent sense of what authoritarianism is. It's a system of governance in which there's arbitrary imprisonment of the opponents of the regime. There are either no elections or fake elections where in the fake elections, only one party is allowed to run. People are required to vote, and the vote in favor of the party is 99.5%. So at that end of the spectrum, we sort of know what the pole opposite to constitutionalism is, but it's also the case that at this sort of constitutionalist end of the pole, there are varieties of constitutionalism. And here's the first comparative observation that I want to make. I've written an article recently basically about Singapore. And I call the article Authoritarian Constitutionalism. The reason I did that is that Singapore is not at the pole of authoritarianism. There are no arbitrary arrests of political opponents. There are sort of real elections. The elections are sort of free and fair. But take the most recent election. Let me tell you the story about the two most recent Singaporean elections. Singapore has been governed by one party, the People's Action Party, since its creation as a nation. The leader of that party, Lee Kuan Yew, just died earlier this year. He was, I have to say, a political genius, one of I think maybe two political geniuses of the late 20th century, the other one being Pierre Trudeau. Both of them faced serious problems of national stability and had to design constitutional institutions that would solve those problems of instability. Each of them solved the problem in different ways. Lee Kuan Yew by establishing essentially a dominant party government. So what happens in Singapore is they have elections every 5 years until the most, let's see, the 2010 election, the People's Action Party won with 80% of the votes. Their elections were, as I say, reasonably free and fair, a certain amount of gerrymandering of districts. The election campaign period is very tightly limited. It's 8 days in which you can actually campaign for office. Obviously, the opposition party exists outside this period, but they can't be campaigning outside the period. So in 2010, the ruling party suffered what everybody regarded as an enormous repudiation. What that repudiation consisted of at the end of the election was that they had won re-election by 60% of the vote instead of 80% of the vote, and had won 83 out of 89 seats rather than 86 out of 89 seats. Okay, so now this year, last Friday, they had an election, regularly scheduled election, in which the party retained office, as everybody knew it was going to do, in an enormous victory, completely dispiriting the opposition. What happened then? Well, on last Friday, the ruling party won the 83 out of 89 seats, exactly the same as that they won before, but this time they got 70% of the vote. So back up from 60. So Singapore, and they don't imprison political opponents. They actually haven't done anything serious about political opponents in maybe 2 or 3 decades. They used to have a practice of suing them for libel and bankrupting them. And one of the leading opponents actually was forced into bankruptcy several times and eventually ended up living off of donations from friends. But he was out, he was still a political opponent. So there you have a system that actually does satisfy reasonable notions of constitutionalism, but it's not, but it is also not Stalinist Russia or a regime that we would fairly characterize as authoritarian. And there is genuine support in the nation for the governing party. Okay, so that I use the example of Singapore, which I will come back to at the very end, I hope, if I have time, just to make the point that there's a spectrum of things ranging from authoritarianism to something else at the constitutionalist end of the pole. And what I want to talk about are not in detail about things like the Singaporean authoritarian constitutionalism or the possibility of non-liberal constitutionalism of a sort that some people say can be associated with a certain kind of majority Muslim nation, like Indonesia, for example, or less certainly Malaysia. What I want to talk about are varieties of liberal constitutionalism, of which the United States is an example, or offers a variant, which is the subtitle of the talk today. Now, to begin, I don't want to begin with a comprehensive definition of liberal constitutionalism for reasons that will appear as I proceed. All that I want to do is to say that liberal constitutionalism requires something like reasonably free and fair elections and reasonably robust protections of civil rights and civil liberties, such as political dissent. There's a complexity that I want to note here that I won't talk about in the main body of the talk, but which we might be able to explore if I don't fully occupy the lecture period. And that is, the complexity is actually relevant to the United States system of federalism, where you might find pockets where you would say, you know, they don't really have reasonably free and fair elections. There they have very heavily one-party dominated elections on the Singaporean model and the like. How do we conceptualize the U.S. as a liberal constitutionalist country with these geographic potential exceptions? I don't want to claim that they're widespread or even that they really exist now. They certainly did used to exist in this country. Okay, so there's a federalism complexity to this story that I just wanted, as I say, to flag. Why am I not offering anything more than reasonably free and fair elections and reasonably robust protections of civil rights and civil liberties? The reason is that the primary reason is that any comprehensive definition that I would offer would be inaccurate in the sense that there are nations that we will want to call liberal constitutional regimes, but that won't satisfy a comprehensive definition of whatever comprehensive definition you offer. So just to take two examples, one about elections and one about civil rights and civil liberties. Suppose you say with respect to elections that liberal constitutionalism requires universal adult suffrage. One can even worry about the adult part if you want, but just let's say universal adult suffrage. Does that mean, if, again, liberal constitutionalism requires universal suffrage, does that mean that the United States was not a liberal constitutional nation before 1920, when the 19th Amendment on women's suffrage was adopted? Or that Switzerland was not a liberal constitutionalist regime until 1971, when women's suffrage was guaranteed at the national level in Switzerland? That seems to me implausible. There are things you might want to say about the United States before 1920 and Switzerland before 1971, but I don't think you'd want to say that they did not at those times qualify as liberal constitutionalist regimes. The problems get even worse if we think about civil rights and civil liberties, and here I'll use an example that I'll carry through on in another context. The example is hate speech regulation. So hate speech regulation is widespread in other nations, including Canada, the United Kingdom, and Germany, and it's constitutionally quite restricted only in the United States. And without taking a position on whether liberal constitutionalism either requires or prohibits hate speech regulation, something's weird in a definition that would say either the United States is not a liberal constitutionalist regime or that Canada, the United Kingdom, and Germany are not liberal constitutionalist regimes. So again, trying to get more specific or more content into the idea of liberal constitutionalism is going to lead to these kinds of anomalies or inaccuracies. So I'm going to proceed without a comprehensive definition, but rather inductively by looking at systems that seem to me clearly liberal constitutionalist to bring out varieties that we can then see in the United States. And I'll begin with the heartland for legal academics who think about constitutional law, which is judicial review, called elsewhere constitutional review. Go lay out the arguments about judicial or constitutional review to link it to to fundamental ideas about liberal constitutionalism. First of all, everybody agrees, I think, that liberal constitutionalism requires general adherence to the rule of law by all public bodies, executives and legislatures specifically. Just again, as a footnote here, in the first of the two Republican debates last night, portions of which I was able to see while waiting in the Minneapolis airport, there was a fairly extensive and not, I have to say, not unsophisticated discussion of the Kim Davis problem in terms of rule of law. Some people were saying, I don't recall who, but somebody was saying what she did was inconsistent with the rule of law. Somebody else was saying what she did was consistent with the rule of law. Here, I use the example just to show that everybody agreed that the rule of law was the thing that needed to be paid attention to. Okay, so now I think there's also general agreement that adherence to the rule of law requires that there be courts that are reasonably independent of control by the political branches. Again, as an aside, defining reasonable independence and then figuring out how to design a judicial system that satisfies the definition turns out to be pretty tricky. Basically, you want longish terms of office and some degree of budgetary independence. It's not clear that you need much more than that, but I'll put those details aside from now. Again, we can talk about them later if we have time. Okay, so now we have rule of law, which means executive officials and legislatures have to comply with the law, and judges whose job is to ensure that the law is complied with. We also have pretty good ideas about how to ensure that the executive will adhere to the rule of law through what's called elsewhere administrative review. And I want to stress that at this point I'm not talking about what in the US we call judicial review. Actually, what I'm talking about in other countries is called judicial review. I once gave a talk in Ireland, and it was advertised as a talk about judicial review, and everybody showed up because they wanted to know how the court should deal with the actions of the immigration authorities in Ireland. They thought I was going to talk about administrative review, but I was talking about US-style judicial review. So the idea behind administrative review is that the way the courts enforce the rule of law against executive officials is that they will consider the legality of actions taken by the executive to determine whether they are authorized by statute or not. And again, I want to emphasize authorized by statute. So administrative review asks, has the executive complied with the requirements of the statutes in place? We're now seeing quite a lot of rather high-level political controversy over issues of executive compliance with the law, with statutory law these days in connection with immigration and the Affordable Care Act. But in general, the controversy is not whether the courts should hear the cases. The controversy is over whether the executive's actions are actually consistent with the law or not. There's, again, general agreement that courts are the place to go to determine whether an executive's actions are authorized by statute or not. If they are authorized by statute, which is the position the executive always takes, fine. The executive is complying with the rule of law. If they're not, everybody agrees that the executive has to bring its actions into line with the law. And even in these controversies, nobody on the side of the executive branch is saying, well, we're going to ignore what the courts say on these questions if they don't rule the way we like. So with respect to actions by the executive, we do have a decent mechanism for determining whether what the executive has done is consistent with the rule of law as embodied in statutes. Again, there's a footnote here about executive action where the executive rests its authority on the Constitution independent of and sometimes contrary to statute. Again, we can talk about that later. My own view is that the analytic questions that arise in connection with those actions, first of all, that those actions are extremely rare. Executive officials almost never rely on executive authority freestanding without some statutory backing. When they do, they rarely do it. When they do it, the analytical issues are, I think, the same as the ones that arise in connection with ensuring that the legislature complies with the law. And here the problem is the law is twofold. First of all, there are statutes. Well, legislatures enact the statute, so you can't talk about them coherently as complying with the statutes that they themselves enact. Rather, we have to think about ensuring legislative compliance with the Constitution. And that's theoretically more troublesome. There are two general solutions that supporters of liberal constitutionalism have come up with. One is the one that used to prevail in many nations and now prevails in very few. And the other is the one that has prevailed in the United States from the beginning and that many nations are moving in the direction of or have adopted. The first is what some political theorists call political constitutionalism. I'm going to spend some time on that because it's something that we in the U.S. are not all that familiar with, for reasons that I've already alluded to. In a system of political constitution, there are legal restraints on what the legislature can do. There are legal restraints on what the legislature can do. There are things like bills of rights. But the courts do not enforce those restraints. My favorite example here, and I looked it up to make sure that I would give you an accurate version of it, is the Constitution of the Netherlands. Now, the Netherlands is a constitutional monarchy. The monarchy part doesn't matter for us. It clearly is a liberal constitutional country, okay? The Dutch Constitution begins with a list of 20 fundamental rights. The heading is fundamental rights. It's a Bill of Rights. And then later on, there's a provision that says, and I'll read it to you, the constitutionality of acts of Parliament shall not be reviewed by the courts. Okay, so now suppose Parliament enacts a statute and you think that it's inconsistent with, actually let me back up. Suppose a legislator proposes a statute that you think is inconsistent with one of the fundamental rights that are right up front in the Constitution. How are those rights going to be enforced against a legislature if you don't have a court to do it? Well, in political constitutionalist systems, the rights are enforced by political means. Citizens are committed to the Constitution's values and to the rights it protects, and they vote for politicians in part on the basis of what the politicians say and do about fundamental rights. So this politician's proposed an unconstitutional statute or a statute that in your view is unconstitutional. You organize politically to deny that person office in the next election. Now, in the United States, we're quite skeptical about the possibility of this sort of political constitutionalism. We tend to think that you can't have a truly liberal constitutional system without our kind of judicial review. The example of the Netherlands shows, I think, that actually you can. It's an okay country in liberal constitutionalist terms. It's not perfect, but the United States isn't perfect either. And it's small, it's true, that may be relevant. It's one thing that's not all that different from the U.S. is that it's actually quite diverse internally. You walk around the streets of Amsterdam, and you're in a cosmopolitan city. There's no question about that. So yeah, it's sort of different from the U.S., but it's sort of the same along some dimensions. A closer example is the United Kingdom before the year 2000, and perhaps in the next few years. Before 2000, the British courts did not have the power to declare unconstitutional legislation that Parliament adopted, and the current government seems likelihood, it's not entirely, we don't know exactly how likely it is, but the current government seems interested in returning to the pre-2000 position by repealing the statute that authorizes our kind of constitutional review. I'm sure we wouldn't want to describe I'm sure that we would want to describe the United Kingdom before 2000 and after 2017 or whatever as a liberal constitutional regime. Now, skepticism of political constitutionalism for the United States might be justified, although I think the case against it turns out to be quite complicated when you work it out. Again, because of time restrictions, I'll just note that the starting point is federalism. Again, basically, there's so many jurisdictions in the United States that there's a troublingly large risk that political constitutionalism wouldn't work fairly well it wouldn't work well in a fair number of places. For example, in towns dominated by a small elite. There's an interesting article about small villages as places where civil liberties violations would occur if you just had political constitutionalism. But, and now I'm going to go more extensively back to the U.S., there's a residue of political constitutionalism in U.S. Constitutional thinking. Remember that in our system, courts do enforce constitutional limitations. So in parallel to political constitutionalism, we can describe the U.S. variety as judicial constitutionalism. The residue that political constitutionalism leaves within judicial constitutionalism is that the claim is that as a general matter, courts should defer to legislative judgments about the constitutionality of statutes the legislature enacts. That's sometimes called judicial restraint. Again, as a side, the language of judicial restraint used to be associated with political conservatives. Its political valence has changed somewhat, and conservatives now defend what for these purposes I'll shorthand as the correct kind of judicial activism. The idea behind the residue that political constitutionalism leaves in our system has two components. The first is similar to that in political constitutionalism. In many instances, legislators actually do want to adhere to constitutional restraints, although sometimes that desire is overridden by purely political concerns. On the latter point, the sort of current poster child for this is a statement that Nancy Pelosi made in connection with the Affordable Care Act when she was asked, do you think the Affordable Care Act is constitutional? And her response was, are you serious? That is taken, I think maybe inaccurately, but is taken as a suggestion that she didn't care whether it was constitutional or not. There's an alternative reading, which is you can't seriously think that it's unconstitutional. That turns out to be wrong, but she might have been saying Yes, of course, I care whether it's constitutional, and it obviously is. Okay, so legislatures actually do sometimes want to adhere to the Constitution. The second is far more important. Second component of this residue is more important. It's that there is often, maybe always, reasonable disagreement about whether a specific piece of legislation is consistent with the Constitution. Principles of liberal constitutionalism are quite general: equality, fairness, freedom of expression, and specifying how those principles apply to contemporary or to concrete problems is not merely controversial sometimes, but reasonably controversial. To take again the clearest contemporary examples, you can reasonably think that substantial restrictions on hate speech regulation, or substantial restrictions on the regulation of hate speech, and substantial restrictions on campaign finance violate principles of free speech properly understood. And someone else can reasonably think that such restrictions are entirely consistent with those principles. Or to take another example involving equality, in the United States, the principle of equality is generally interpreted to mean that equality is satisfied when statutes apply to all in equal terms, and in particular when statutes make no reference to race or gender. In the race context, that statutes are colorblind. We satisfy the requirements of equality by having colorblind statutes. We're committed to a notion that in the literature is referred to as formal equality, even if those statutes have a substantial differential effect on different groups by disadvantaging racial minorities more than they do a racial majority. In contrast, in many other systems that are liberal constitutional ones, on my, again, inductive definition, equality is understood to require rough equality of outcome. And facially neutral statutes with disparate impacts are constitutionally questionable. Okay, so then what do you do in the face of reasonable disagreement about the specific meanings of these liberal constitutionalist commitments? One response is judicial deference to legislative judgments. I, as a judge, think that hate speech regulation is constitutionally impermissible, but the legislature has taken another view of the matter. Its view is a reasonable one. I don't share it, but I can see how reasonable people could take that view, and given that, I will uphold what they do. Okay, so judicial deference to the legislature might be seen as a response to the kinds of things in our system that are parallel to what is relied on completely in political constitutionalist systems. There are a couple of other ways to understand the existence of disagreement about what liberal principles mean in specific contexts, and because of time, I will just go through them relatively briefly. One is, I've already alluded to, I call it problems of historical contingency. Liberal constitutionalism is a historical achievement in the sense that some nations increasingly satisfy its requirements. Again, free speech and elections are decent examples of this. So if you go back to 1910 with respect to elections, women were not guaranteed the right to vote by the national constitution, and more problematically, African Americans had a formal guarantee of the right to vote. Widespread terrorism in the South effectively denied them the franchise. You still might want to say that in 1910, the U.S. was a liberal constitutional regime with the federalism problem that I alluded to at the beginning in the background. At best, this would be the U.S. fell short of liberal constitutionalism then, but the shortfall was historically contingent. And this notion of shortfalls might be a more general one. And I'm going to finish with a suggestion, hopefully provocative, that we might want to start thinking about the United States as being stuck with a non-liberal form of constitutionalism. The idea of shortfalls is that there might well be a best comprehensive account of what liberal constitutionalism requires, but all real constitutional systems will fall short in achieving that ideal. The shortfalls are inevitable. So suppose you have your own idea about what liberal constitutionalism requires, and you observe that the system, Canada, the United States, isn't consistent with that. That wouldn't remove the United States or Canada from the list of liberal constitutional systems. It would simply mean that each one falls short of what liberal constitutionalism requires, each in its own way, perhaps. At some point, and this is really leading to the conclusion, the shortfall becomes so substantial that the country actually can't be on the list of liberal constitutional nations anymore. And the provocative observation, I hope, is that it might be plausible to think that the United States has fallen so far short that it isn't a liberal constitutional system. On that view, the United States doesn't have a variety of liberal constitutionalism. It has some sort of non-liberal or illiberal constitutionalism. And I'll just sketch the argument without fully endorsing it. Recall that liberal constitutionalism requires reasonably free and fair elections. The argument that the U.S. has fallen permanently short is related to the U.S. system of campaign finance regulation, which is constructed to meet with the Supreme Court's interpretations of the First Amendment. That system may so substantially limit political competition to those who are able to raise quite large sums of money, which means limits political competition to those who are able to extract money from a relatively narrow segment of the population, that our elections should no longer be characterized as reasonably free and fair. They're more like that system is stabilized by the Supreme Court's interpretation of the First Amendment. You can imagine changing the doctrine that has generated that stabilizing effect, but the most promising ways of changing the doctrine, I think, run quite deep in the sense that if you adopted those other ways of thinking about things, you would have to, thinking about campaign finance regulation, you'd have to start thinking about other aspects of free speech law to which the campaign finance law is currently connected. Again, the most obvious example is my view is that the best alternative way of thinking about campaign finance regulation has fairly strong implications for questions about the permissibility of hate speech regulation and a range of other issues not directly connected in the case books to campaign finance. Okay, so the effect would be, if this pessimistic account is right, the effect would be that the stabilized system of campaign finance in the United States makes our elections more like the elections in Singapore than we would like to think that they are. And that would be, Singapore is, I want to stress, it's not a terrible place. But it's also not a liberal constitutional place. And it might be that the United States is closer to Singapore than it is to the idealized liberal constitutional system that I think we most of the time think we have. Thank you. We do have some time for questions. You have to get out. Yeah, right. So in the back.
Thank you very much. My question revolves around women not being written into the Constitution. Black men got raised from 3/5 to whole persons, but women were never written into the Constitution by gender. I think we have 3 states that are yet to ratify the Equal Rights Amendment, which says equal rights under the law shall not be denied or abridged on account of gender. And that was back when I was 1969, Betty Friedan, Gloria Steinem, and Anita O'Brien, who thought that with Florida orange juice money that we would have same-sex bathrooms and gay marriages. Well, we have same-sex bathrooms and gay marriages. Where is the ratification for women to be written into the Constitution?
Yeah, so I think that example is, I would put that example in the category either of shortfalls or historical contingencies. Maybe the latter more than the former, precisely because of what I would say the filling out of gender equality in statutory ways rather than constitutional ways, and in statutes that are sometimes referred to as super statutes or quasi-constitutional statutes.
The Lucy Ledbetter.
I'm sorry?
A Lucy Ledbetter statute.
Yeah, right. But quasi-constitutional isn't constitutional. I don't want to lose that observation. And so, again, the historically contingent point would be to say, well, maybe in 5, 10, 20 years, the ERA will be adopted and be fully constitutionalized. That would be the thought. Yeah.
Could you expand briefly on your reference to Pierre Elliott Trudeau as an enlightening?
Thank you.
Sure. Yeah. So the problem Trudeau was facing was the possible fracture of Canada over the issue of Quebec. And he had as I say, it was a genius idea of saying what we need to do in Quebec is reconceptualize the nature of, we have to do in Canada, is reconceptualize the nature of Canada from a binational country to a multicultural country. And that certain amount of working out, that's embodied in the charter that Trudeau sponsored in 1982. It's why he sponsored the charter. And in the succeeding 30 now some odd years, it seems to have worked out. Canadians now don't think of the nation as a binational Anglophone, Francophone nation. They think of it as a multicultural nation with Anglophones as one of the cultures and Francophones as another culture, and Asian origin Canadians as yet another culture, and the First Nations, their term for what in the U.S. we call Indians or Native Americans, as yet another culture. And it's worked in ways that Trudeau anticipated, but I think maybe not many other people did. Yeah.
The Dred Scott decision dealt with property rights, not even property. I think they basically ignored that decision. So don't we have like a moral law that can use either the judicial acts, which we can ignore, the executive legislature could ignore the judicial acts, and say you're on the Constitution, you violated the moral law.
Right. So the answer to that would get us into an extremely large discussion. The short answer is, I think, that Lincoln said he was under no political duty to comply with Dred Scott, meaning that it was permissible for him to propose legislation that other people would say fairly, reasonably would say was inconsistent with Dred Scott. So he he said that he was not required to take it as, in his terms, a political rule. He did say, and he didn't say it in these terms, but his analysis was that I must comply with a coercive order from the courts directing, in Dred Scott, the return of Dred Scott to slavery. And in the face of his position was that in the face of a coercive order directed at him in connection with a specific case, he would have to comply, even contrary to his own best view of the Constitution. That is a defensible position. I have written it's not the only defensible position. That is, one can defend the proposition that under some circumstances, even ignoring a coercive order may be lawful in some deep sense. The conditions are, I think, quite extreme. That is rare that it would happen, that it would be justified. But I don't, just to take the current example, I don't think that as a matter of, I think that there is something to be said for what Kim Davis did. In the end, I think it's not justified because the conditions are, all the relevant conditions aren't in place. But it's a more complicated problem than much of the, for me it is, a more complicated problem than for what, than is indicated in much of the commentary.
Well, who checks the judiciary branch?
Yeah, right. So well, Lincoln's position is we have elections and we replace judges, even life-term federal judges. The state level, it's easier. You've got elected judges, so if they mess up, you throw them out. I actually don't have any problem with that. Again, I disagree with many of the recent instances where that's happened, but as a matter of fundamental principle, fine with me.
So we have to turn over the classroom, but if you have questions, Professor Tushnet will be here for another 10 or 15 minutes. Thank you.